Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 18th, 2026. We are on voting list number 10, and we are going to start off with Senate Bill 895, which is withdrawn. So the motion is withdrawn. Is everyone okay being recorded in the affirmative for the withdrawn motion? All right, excellent. We'll now go on to Senate Bill
Senate Bill 180 establishes that it is lawful for a person to intercept an oral communication if, one, the person is working as a fair housing tester for a fair housing testing program operated by the federal government, the state, a local government, or a nonprofit civil rights organization. The person is a party to the communication, and three, the interception is being made for the purpose of obtaining evidence of a fair housing violation under federal, state, or local law. The contents of an intercepted oral communication may be used only to enforce federal, states, or local fair housing laws. Otherwise, the contents of an intercepted communication and any evidence derived therefrom are inadmissible in any trial, hearing, or other proceeding in or before any court, grand jury, department, officer, agency, regulatory body, legislative committee, or other authority of the state or political subdivision of the state. There are no amendments. This bill passed previously this committee in 2025 and 2024.
This is the same bill as noted that is passed a few times out of this committee and passed the body. And I would just urge you to continue voting to support the bill. And I make a motion to move Senate Bill 180.
There's been a motion for a favorable. It's been seconded. Do we need a roll call? So roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
I'm looking something that may pass for the moment.
Senator Folden.
No, and to explain my vote, I want to be sure that I'm not trying to ruin the good senator's birthday. But I mean, we still haven't even moved 661, which is deals with imminent bodily injury or death. And I know it's on the list here, but this doesn't deal with anything imminent. And I have concerns about piercing the two-party consent on that fair housing when we can't even come together on a decision to move something that's meaningful in protecting victims. So my vote will be a no.
Senator James.
I know, and I also, to briefly explain, because I have such high regard for the senator, but I don't know of a standard by which we would then not continue down this path and ultimately eliminate this policy that we've had for a long time and law that we've had for a long time. I don't know any kind of confines here. And I also agree with my senator from Frederick, which is that, to me, if we're going to go down this path, it ought to be for something so extraordinary, so egregious, and so potentially harmful and irreparably harmful that we could have a limited exception with a governing principle. So for all those reasons, I can't support the bill.
Senator Henson.
Yes.
Senator Love.
I really struggle with this bill. It's a really, really important issue, and we should be doing all we can to get rid of discrimination in housing. Unfortunately, I'm still a no on this bill because it's the only, as far as I remember, it's the only civil exception to our two-party consent, and that is very concerning to me to open it up in that way. So, unfortunately, I'm still a no.
Senator McKay.
So I'm going to be a nay, just for the simple fact that I acknowledge that we still have bad actors violating fair housing. but I don't think this is the right way, just for the simple fact, I don't know if there's enough data protections that protect the guardrails for what may come from this.
Senator Charles?
Yes.
Senator West?
I'm sort of Senator Love's position, and I've always had problems with this bill. I would feel more comfortable if we had moved the other bill, the 660.
We are going to move that bill.
What's that?
We are going to move that bill.
We are going to move that bill? All right. Well, if we're going to move that bill, then I'll vote yes.
Chair Smith?
Yes. All right, Senate Bill 180 passes 6-4. We now go on to Senate Bill 250.
Senate Bill 250 replaces the existing substantive portions of the Maryland Uniform Simultaneous Death Act with provisions that substantially conform to the more recent Uniform Simultaneous Death Act adopted by the Uniform Law Commission in 1993, addressing circumstances in which the timing of a person's death in relation to another person's death or another event affects the disposition of property interests or rights. For example, if a person would receive property under another's will if they survive them, or has other significance under specified legal instruments. The updated act requires a person to have survived another person's death or other event by 120 hours in order to be deemed to have survived for purposes of the disposition of property interests or rights, or other purposes under a provision of a legal instrument that relates to a person's survival of another's death or another event.
There's been a motion for a favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Go ahead, take your time. This is Senate Bill 250. All right, Senate Bill 250 passes unanimously. Let me see. All right, Senate Bill, Mr. Shamari, we're going to stay with you. Just Senate Bill 691.
Senate Bill 691 alters the time period within which a holder of trust money must distribute trust money to a purchaser following termination of a residential real estate contract under a contingency clause. It alters the definition of contingency clause that is applicable to the circumstances under which a residential real estate contract may be terminated by a purchaser. There are no amendments.
All right, Senator James has moved favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 691 passes unanimously. All right. What about
814.
Yeah. Shamar, we're going to stick with you. Just Senate Bill 814.
Senate Bill 814 establishes that a service agreement or any part of a service agreement entered into before June 1st, 2023 may not be effective for more than 2 years or purport to run with the land or bind subsequent bona fide purchasers, purport to create a lien, encumbrance, or security interest on the residential property of a party to the service agreement, or 3, allow the service provider to assign or transfer the right to provide services under the agreement to another person without notice or the consent of a party to the agreement. Any agreement that violates these restrictions is void and unenforceable. However, the bill is applicable only to agreements with a service provider that has forfeited the right of the provider to conduct business in the state and on or after June 1st, 2026, is defunct and considered not in good standing with the State Department of Assessments and Taxation. The bill also establishes a related cause of action and authority to seek certain relief if an agreement in violation of the bill's prohibitions is recorded as specified. The bill takes effect June 1st, 2026. There are no amendments.
Thank you, Mr. Chair. I wrote down that there was a concern about mandating industry to use a privately owned database. Was that addressed at all?
I think that was a different bill.
Am I on a different bill?
Yeah.
What bill are we on?
This is 814.
That's what I have in my notes.
That was the multiple listing service provider bill,
Right.
I think.
I wonder why it got here. Okay, my apologies.
It's been a motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 814 passes unanimously. Senate Bill 933.
Yes. Senate Bill 933 proposes a constitutional amendment that, if approved by the voters at the next general election, authorizes the chair of the Commission on Judicial Disabilities to take specified actions in the event of a member's recusal or disqualification or the expiration of a member's term without a replacement. Specifically, the chair may, 1, recall a former member to serve as a temporary substitute member, or 2, request that the governor appoint a temporary substitute member or extend a current member's term. On request of the chair of the commission, the governor may appoint a temporary substitute member for a specified period of time or extend a current member's term until a replacement is appointed. Any temporary substitute member is subject to the same qualifications that were applicable to the member for whom the substitute is temporarily appointed, may not have been rejected by the Senate for appointment to the commission, and if the member is a judge or an attorney, must be a member in good standing of the Maryland Bar. The bill also withdraws and repeals Chapter 848 and 849 of 2025, which proposed a similar constitutional amendment. So that previous constitutional amendment that passed the body had all of these provisions. This bill repeals that and just adds one additional, that a person who has been rejected by the Senate for appointment to the commission cannot be reappointed.
There's actually one amendment that needs to be added to this. Somehow this got entered in incorrectly as chair, but it's actually, I personally sponsored this bill, so you need to have just a sponsor amendment just to make sure that oversight was corrected. So, is everyone okay with that?
Oh, yes, sorry.
Yeah. Yep, no worries.
Yep, sponsor amendment to change
Got
to
it. Yep.
Senator Smith.
Is everyone okay with adopting the amendment? You understand the, yes, you understand them. It's motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 933 passes unanimously.
Give me 1 second, let me just look that one up. Okay. Okay. Okay.
Senate Bill 823 alters the appointing authority and method of appointment for members of the Maryland Parole Commission. Specifically, the bill repeals the requirement that the Secretary of Public Safety and Correctional Services, with the approval of the governor and advice and consent of the Senate, appoint parole commissioners, and instead requires the governor, with the advice and consent of the Senate, to appoint commissioners from among nominees chosen by a panel consisting of specified members. The panel must submit to the governor the names of at least 3 qualified nominees for each vacancy. The governor's Office of Crime Prevention and Policy must provide staffing for the panel.
Senator Fulton.
Just for clarity's sake, this takes out the Secretary of Department of Correctional Services?
The Secretary is a member of the panel, but she would no longer have the
Sole discretion.
sole authority to make the appointment.
Get to the issue you elucidated during the hearing. I know we talked about this, but
Yeah.
so it puts this back into, well, not back into, but it gives us more oversight and I think public accountability for that process. Some of the criticism was that a lot of folks have been funneling through the department, and there's been a lot of, so I understand those concerns. This bill seeks to address those concerns, adds a level of transparency and accountability. So yes, the secretary will no longer be solely responsible for appointing.
Wonderful. I'm just, one moment, but, so I'm looking, and we have the executive director of MPTC, we have Secretary of Public Safety, Public Defender, State's Attorneys. Okay, what do we need the State Superintendent of Schools for on that? I'm just not really sure why that was in there.
There's a component of education that's provided to incarcerated individuals, public education, so just having that person at the table.
For someone that's looking to grant parole? I mean, the concept of what you're doing, I agree with and I appreciate, but we can get too many, fingers into this process that it just doesn't, what qualifications does the State Superintendent of Schools have in any appointment process for a parole commissioner? I question that. I mean, I mean, you'd be better off to have someone from a law enforcement background that could at least speak to the crime and what they're dealing with. I mean, our own, and people might say, well, the Secretary of Public Safety and Correctional Services would be that person, but that person clearly in the current capacity has never been in law enforcement and doesn't give anyone that perspective. We've got a prisoner rights advocate. We've got a victim's rights advocate. 3 members of the general public, great. I just don't, social workers, okay. I just don't, these are people that have their expertise. I just don't understand why we would need the state school superintendent of schools.
I mean, we had that discussion before I put the bill in. I've given you the explanation, but if you'd like to, I mean, if you have by my count, if you make a motion to remove that person, you have an odd number of people, which is just fine.
So originally I'm a down on this bill, and then after reviewing it, I mean, and that would be one of the reasons. If we want to, I would like to offer an amendment that we remove the State Superintendent of Schools, and then I think it's more meaningful that in the concept of what you're looking to pass. So if you're agreeable to that, I would like to make that a motion and remove that person. You second it?
Senator,
So you seconded it? He seconded it.
Senator Muse and West, second together. That's just That's just fine by me. I mean, it leaves the odd number. Yeah.
You know, I'm just got a question, but I know we have a lot of recidivism, and I honestly don't have the data in front of me. So I feel like this panel would be great to deal with reducing recidivism and maybe mapping out better, programs before people are back in the community. What I'm having trouble with here is, by the description of the members, I don't see people with a high level or any expertise in some of the issues I think are most salient to when someone should be granted parole. I don't have the words to describe them particularly. I could try, but I'm just saying, Senator Folden was sort of alluding to this just by one individual. That individual may or may not be clued into the very important issues about, eligibility for parole and success for parole. So I wish there were some language in here that said, even if we're going to go with these broad categories, that we also ensure some expertise, and expertise, not ideology, about, successful decisions about parole. And with all due respect, because I know this is, good, it's a bill that, has good intentions, and we probably should modernize the way we're doing it now. But so I have some hesitation about us not tightening up some of what we're looking for in these broader categories.
I think I push back a little bit on that, but even understanding that, I think that given the status quo, this commission, you have members that are going to be appointed by the governor, vetted by the Senate Judicial Nominations Committee. They're going to be the ones that help go through and select commissioners. The current process is one that is sole sourced. And so you've got people with varying degrees of expertise in prosecution, public defense, public defenders are there, people with social work background, people with an educational background before the amendment. So I think you've got a diverse array of folks that are going to help select these folks who have who have that expert period of expertise. I mean, I think just given the status quo, it's a great improvement from the process, giving a level of transparency and greater accountability.
I'm with you on modernizing how it's done now, and I think more eyes on the issue is very important. So I guess it's just, hopefully the process will work, that people will, within these broad categories, think about people that, have some interest and also some talent in the area. Can I ask you just one other question? I don't know how often everyone meets, but I notice I don't want there to be designees that go to these meetings, but I don't know how frequently they meet. So you probably vetted whether or not the state superintendent of schools could actually attend these meetings. Maybe they're infrequent, I don't know. Are these infrequent meetings? I mean, like you get the appointments and then you only meet when you need to fill a vacancy or something?
No, so I mean, right now, there's no commission that appoints, it's just the secretary.
Oh, okay. Well, I guess what I was saying is I hope we don't end up with designees. You're not allowing for it here, but I don't know how demanding the job is, given, I think about the superintendent of schools.
Understood.
How busy they are, so I don't know how that would work.
Right now, the commission, I mean, they're full up right now, right? We just approved the last four this year, I guess. We did 4 this year.
What did you say?
Exec noms just approved, they're full up this year, they're now, so it's full. But we approved the last 4 nominees this year, but I think most recently, we had
All right,
2
just a thought.
2 weeks ago, or 2 months.
All right, thank you.
Yep. Senator Sidnor.
Thank you. And I know you are amenable to Senator Folden's modifications, but I want to make certain that I'm understanding it correctly. So there's a commission that consists of 10 people. That list that we have is what the governor, with the advice and consent of the Senate, would be approving in terms of being on a panel. So you're taking out the state superintendent of schools doesn't necessarily do anything to what the commission consists of, but it seems to be affecting the panel that the governor gets to select from. Am I misreading that? And Senator James was talking about, she didn't see anybody on here that could help to kind of figure out whether or not people were ready for release. And, right?
Well, I was looking for people with some expertise on how to get people involved with that kind of, we have recidivism. I understand this panel is selecting, a different group, but I didn't see us pinning it down with some people with expertise in the issues that would ultimately be decided by the group that gets selected.
So,
Pretty verbose, apologies.
well, my point is this. If you're looking to have people to go back into society, who better on the finger on the pulse about the skills that one needs to get back into society? I don't know if a formal motion was made to remove the state superintendent of schools, but to me, it makes sense to leave that person on there.
At the end of the staff level, goes through the process, determines who is, and that kind of stuff, eligible for parole and that kind of stuff. And then it is presented to the commissioners and all that. So I'm not exactly sure. I hear what you're saying, but that should be a requirement on the staff level, not necessarily on the level of who's going to be approving the staff's recommendations.
So this list that we're picking from, it says the governor, with advice and consent from the Senate, shall appoint members of the commission from among nominees chosen by a panel consisting of these individuals. What am I missing?
Well, you had said that, I thought you were talking about from an education standpoint, that they needed to have somebody who was there who understood educating and returning citizens, da-da-da-da-da-da-da.
Right,
I'm not exactly sure that applies, because I don't think it gets at that level, for the group that is going to create the list of people to pick from.
No, but this is the people who the governor would be picking from. This is like a pool that we're creating.
I think you're both kind of talking at the same but past each other. So like hearing examiners are right. They do handle the lion's share of the cases. I think it's for life sentences or murder, it's a requirement that the commissioners hear those cases, but the hearing examiners do the lion's share of the work. But you are right in saying that ultimately when you're evaluating someone's ability to reenter society, there is an education, I mean, you might want to have someone with like a background in education and understanding how that can, help someone stay out of the life of justice involvement. So, but understand, the school superintendent, I was thinking of like maybe something with higher education or a community college, something like that would be most appropriate. I don't know. Yeah, I mean, yeah, something of that nature may be more appropriate because it's not, it's like post-secondary education, yeah.
Under the blueprint, they're kind of putting this vocational stuff in there so they are preparing them. Correct. I mean, either way, I guess my point is you don't want to cut out that field.
No, I hear you. We could, let me do some more research on that in terms of like vocational training or post-it, but I'd like to advance the bill just given the hour. But we can always do a floor amendment on that because I do think it's a relevant point. Well, I mean, I think you're right, though. With your amendment, yeah. Yeah. You have to, and then again, if there's something for higher education or vocational training, then we might have to reconfigure because I do think the number should remain odd, but yeah. Yeah, the amendment's been adopted, so there's a motion for a favorable with the amendment. seconded. Is everyone okay being recorded in the affirmative? Down?
Down.
Okay. Senator McKay is down. The Senate Bill 823 with the amendment passes 10-1. All right. I think, do we have our packet of amendments?
Correct.
All right, great. Senate Bill 274.
Senate Bill 274 alters state statute related to housing discrimination to prohibit a person from acting in a manner that has a discriminatory effect. The bill also specifies that the prohibited acts in Section 20-705 of the state government article are discrimination regardless of intent. However, a person has not violated a prohibition in Section 20-705 if, one, the act was without discriminatory intent, the action was necessary to achieve one or more substantial, legitimate, and non-discriminatory interests, and the person could not have achieved the substantial, legitimate, and non-discriminatory interest by less discriminatory means. The bill also authorizes the Department of Housing and Community Development to adopt regulations to carry out its statutory responsibilities related to affirmatively furthering fair housing. Amendment number 1 is technical and changes the title. Amendment number 2 alters the definition of discriminatory effect by deleting creates, reinforces, or perpetuates segregated housing patterns, and makes clarifications on terms by deleting regardless of intent from two provisions in the bill, and changes from and to or on page 5, substantial, legitimate, or non-discriminatory interest.
Sure. This is, for me, a bill that we had heard last year, but I think we ran out of time. It had passed the House. I believe this, the cross-file has already passed the House and is on its way over here. Essentially, with everything that's happening at the federal level, and there was an executive order that the president put out to undercut this whole idea of disparate treatment and throughout. So this essentially is codifying what the law has been and ensuring that there's a tool that is available to help sniff out cases where there are actions that happen that are discriminatory. So with that, I move the bill.
Wait, hold on. Is this the
amendment? I'm sorry.
Yeah, I just want to make sure.
The amendment. My bad.
Just to put it on the record, I mean, you consulted with the stakeholders, all stakeholders, and I mean, the revisions in the bill are, a lot of them are stylistic and technical, but everyone's had the kumbaya moment. It was consensus. Let's move the amendment. And all right, great. Go ahead, Senator West.
So in my packet, I've got some testimony from the Multi-Housing Association favorable with amendments. Does this amendment satisfy the concerns of the MMHA?
I'm not with, I mean, look at what their response was. Right, the regardless of intent was stricken. That was one of their requests. Discriminatory effect, I believe that was also, thank you. I know the regardless of the intent portion, that was struck. Yes, yeah, it was, right, correct, right. It wanted to strike or creates, increases, or reinforces or perpetuates segregated housing patterns. That was struck, as well as the language regarding regardless of intent that it was
Okay,
struck.
it appears as if the amendment does
Yes.
put into place the suggestions of the MMHA. That's very helpful. Thank you.
Well,
Clarify, so am I reading it right that this would be sort of like a disparate impact kind of legislation, but you don't, we haven't changed the language that says if you don't violate the act, does not violate, has not violated a prohibition without intent. So this is an intent, you have to be intentional as well as have a disparate impact? Is that the right way to read this? Does that make am I right? Oh, and not only that, you have to have, oh, I see. You don't violate the act if you don't have an intent. I gotcha. It was necessary for a legitimate, different reason, and there wasn't another way to really achieve that purpose.
Exactly.
Okay, now I understand. And that is tracking the federal policy,
yes.
right? That's, so we're
And
right
state
there.
law,
It's
too.
not kind of different, so we don't have the chance of the courts trying to discern word changes that we made.
I think this tracks with federal fair housing.
Thank you very much.
Now the bill's before you as amended. Further discussion? Is there a motion? Motion's for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 274 with the amendment passes unanimously.
Got insurance?
Senate Bill 747 requires unit owners in residential condominiums, subject to limited exceptions, to maintain certain insurance coverage that meets specified requirements. Unit owners must provide proof of the insurance to the Council of Unit Owners annually and upon request. If a unit owner fails to maintain the required insurance, the Council of Unit Owners may obtain a policy on the owner's behalf and charge the premium as an assessment against the owner. In regard to an insurance policy acquired on behalf of a unit owner under these circumstances, the insurance carrier must pay directly to the Council of Unit Owners the portion of the council's deductible that the unit owner is responsible for as specified. There are two amendments. The first amendment just pushes the effective date to 2027, and then there's another amendment that I can explain. There's one amendment just to change the effective date, and then there's another amendment that's in your packet, 973, 927. So do we need to adopt the first one and then?
So the First Amendment, pushing back the effective date, has been moved, seconded. Everyone's okay? All right.
Okay, so the Second Amendment, 973, 927 /1, that was the work group amendment. The first part of the amendment is technical. The Second Amendment provides that if the cause of any damage to or destruction of any portion of the condominium originates from a unit, the owner of the unit where the cause of the damage or destruction originated is responsible for the least of the cost of the repair of the replacement, the amount of the Council of Unit Owners property insurance deductible, as specified in the insurance policy, or $25,000. That was a change from the $10,000 that was under current law. B, the bill as amended exempts condominiums not composed entirely of detached units. It deletes a requirement that the unit owner insurance policy cover personal property and contents of the unit and loss of use coverage. It adds clarifying language that requires dwelling or building property coverage of at least $25,000 or an amount necessary to replace improvements and betterments made by the current owner or acquired from any previous owner other than the developer. And finally, it deletes the ability, it takes out of the bill, the ability of the council to acquire on behalf of the unit owner and charge an assessment, and provides that the absence of insurance does not limit an owner's responsibility.
Thank you, Mr. Chair. So I just have a question then. So I'm looking at the letters of concern and unfavorable letters, and we've had several amendments. So Shamari, do any of these amendments then help with one of the concerns by the insurance that they would no longer be able to offer same condo unit owners policies in Maryland they offer in other states, creating these state exceptions, increases costs? So does anything address that, the idea that we're now going to inadvertently, and this is my concern, is because we did, not we, again, this body moved something years ago that inadvertently added significant hikes to those that are in these condo and co-op associations that are historically owned by those on fixed income, elderly or the like, and was causing great impacts on their financial well-being by moving that bill, and still we haven't fully remedied it. So I just worry about the unintended consequences, and I don't see anything in the amendments that would satisfy the concerns.
So there was some attempt to address that. We took out that the Council of Unit Owners could acquire an insurance policy on behalf of the unit owner.
Right. So, and then it would also, I'm sorry, Shamari, go ahead.
No, go ahead.
Apologize. So then also they would, if I'm reading it, it was saying something about that it would also have a drive in the association fee, like minimum, where was it at? Permits the association to obtain coverage for the unit owner and bill the unit owner accordingly.
Right, so we took, that part is out of the bill.
That part was taken out?
Right.
Okay.
And,
Okay, thank you.
yep.
So it may or may not assist. At the end of the day, what we're doing, if you're worried about what this cost is going to be, we're talking $8 additional.
So we motion to move the amendment. Seconded. Is everyone okay adopting the amendment? All right, now the bill as amended is before you. Is there a discussion or a motion? Is the motion for favorable with the amendment? It's been seconded. Is everyone okay being recorded in the affirm? Senator Folden is down. Everyone else is yes. Oh, yeah. Let me say. All right, so thanks. I want to just compliment Senator McKay and Senator Kramer. Both had similar legislation. They were able to work together to put forward the bill we just passed. So thank you, Senator Kramer, for your work. And thank you, Senator McKay. We're going to go to Senate Bill 729. Sorry, Shamari, we're rolling with you hard today.
Yep. 729. Senate Bill 729 makes various changes to the governance of mobile home parks and obligations and responsibilities of park owners, their agents, and residents. But the amendment, there's an amendment in your packet. That's Amendment 783227. And what that amendment does is it strikes most of the bill and simply expands the Access to Counsel program and applies that to mobile home park tenants.
Thank you, Mr. Chairman, and thank you to the committee and for the commitment to continue to working on this. Our Mobile Homes Act has not really been touched in substantive part since 1980 when it was adopted, and we've done a lot on our landlord-tenant code to make sure it keeps pace with the market and with the needs of tenants and landlords over time. So I know that there's a commitment to make sure we continue working. I do want to be responsive to the tenants, to the park owners, to the mobile home owners, and then also to the concerns that we heard at the bill hearing as well. And we need a little bit more time to be able to work on the code more comprehensively. But starting with the right to counsel, I think, is a meaningful start for the tenants who need some relief right now. But it was not enough time this session to be able to get the entirety of the bill to a good enough place. So I do believe that the amendment that we have, it strikes a balance to give some relief to those tenants that do need something before next session. So I appreciate the committee's support if that's the will.
Make a motion to adopt the amendment. Second, yeah, that's it. All right, now the bill's before you as amended. Motion's for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Yeah, yes, I think so. You get some smartest people in the room. All right, so Senate Bill 729 with the amendment passes unanimously. We're now going to go on to Senate Bill 941.
Senate Bill 941 requires the Office of Tenant and Landlord Affairs within the Department of Housing and Community Development, in collaboration with the Office of the Attorney General, to develop a plan to, 1, identify severe health and safety risk properties in the state, 2, expand the structure of the Office of Tenant and Landlord Affairs to address severe health and safety risk properties in the state, and 3, provide effective interventions to mitigate predatory, non-compliant, and negligent landlords of multi-unit rental properties in the state. DHCD must submit the plan and recommendations to the Governor and General Assembly by August 31st, 2027. The bill takes effect July 1st, 2026, and terminates December 31st, 2027. There are no amendments.
Been a motion for favorable. It's been, I'll second it. All right, we'll hold. Yeah.
So I'm just reading the Attorney General's letter in regards to this, and it's talking about the housing codes and standards associated with enforcement in Maryland are administered at a local level. The current role in landlord-tenant matters, as they have the Consumer Protection Division, currently receives and responds to landlord-tenant complaints. A statutory mandate is not necessary to achieve coordination. They have existing working relationship and are well-positioned to coordinate the landlord-tenant issues through existing channels. So it's as rare that I'm going to say this, but obviously the Attorney General's office, and I see their concerns. I don't know why. I've been consistently on this about legislating things that are already within an existing working relationship and network especially because it involves the OAG's office. Again, we're making more government. We're widening the scope of what their responsibilities are. They're already stretched thin, and I just don't know that any of was there any amendments on this that addressed any of the OAG's concerns, Senator?
The requirement for them is to adopt a plan. That's what the bill does. And I think that the spirit of their testimony speaks more to implementing a plan. So I don't know if there was confusion on their part when they were drafting the letter, but if you read the letter, it talks about what they would need to do to implement some sort of regulatory scheme. The bill does not require them to implement a regulatory scheme. It simply tasks them with looking at the existing resources, the existing authorities between DHCD and OAG and the new Office of Landlord Tenant Affairs to identify the problem landlords and to see what those two agencies could do with better coordination to provide more support for tenants when they do have a chronically bad landlord. But it doesn't require any sort of implementation, and what you're reading there is referencing what they think would be a challenge with implementing a plan. But that's not what the bill does.
Okay, yeah, I mean, I see that, and they reference your statement about with the final report, with developing a plan, identify severe health and safety risk properties, and recommending interventions to address the several areas that you're talking about, predatory, non-compliant, negligent landlords. The OAG shares their sponsor's commitment to protecting Maryland renters from substandard and hazardous housing conditions. As the committee considers this legislation, they have a complete information about existing enforcement landscape and certain operational considerations that may bear on the study's design and ultimate recommendations. So what they're saying is that they already do all these different things in coordination with the different bodies. So, I mean, so this is more or less, in your opinion, this is a study to determine, I guess, if it can be done better?
They don't coordinate, and more or less a study, but a study that would be a plan on how we could have better coordination. But certainly we have the right to ask them to survey the existing resources and to get back to us with a plan on what could be done. We could implement some sort of policy in the dark, but I think they're in the best position to look at what authorities they have, what authorities they would need to be able to meaningfully intervene in these circumstances. But we could have drafted the bill to say a mandate that you must do this, but we think they're better positioned to be able to tell us what they can do effectively. So it's just a plan that they would adopt under the bill, and certainly we have the ability to ask that of our agencies to come back to us with a meaningful plan.
Sure, and I understand that. I mean, was there I guess I'll have to look here. I was trying to see about the fiscal note on it was, what, 100,000? Because when I'm looking at the committee testimony, it's talking about, you know, there's already local code enforcement offices. So, okay, I appreciate it. Thank you for the information.
Thank you.
Thank you, Mr.
I guess where I'm struggling a little bit is that the Attorney General highlights a different problem or different issue. He says housing code standards and associated enforcement authority in Maryland are administered at the local level. Each of Maryland's counties, municipalities has adopted its own housing code with its own inspection infrastructure, violation standards, and fine schedules. This localized structure means that there is significant variation in housing standards and enforcement capacity across the state. Any plan developed under this bill that contemplates statewide fine structures or centralized enforcement would need to carefully account for this existing framework to avoid conflict or duplication with local authority. The OAG would encourage for the study to examine how state-level intervention plan can complement rather than supplant the work of the local code enforcement agency. So what I would hope the bill would have in it would really be a large contingent of local officials Because it sounds to me like what the Attorney General is saying is that at the state level, without us having the local elected, local county representation and the driving force of it, we would be developing a plan that is not collaborative and may well be conflicting. So to me, the bill ought to be amended to, if the counties would support it, I guess, maybe, you know, I didn't ask them, but to me, this should be, if it's going to be truly collaborative, it can't be a state-level collaboration alone. It has to be a state and local report and study. Otherwise, the Attorney General and the state-level people are certainly going to be peppering our county people with lots of questions, or they'll be reporting in a vacuum. But either way, there's no place in the legislation to fully appreciate the importance of participation by the locals as full members of this study. That's where I'm coming from. What do you think of that? I mean, that question, and how can we, you know, address that?
I appreciate your question. The bill is not complicated, and it does not require the local jurisdictions to do anything or change anything that they currently do. The purpose of the bill is that we have these local rules in place. We have the code enforcement inspections. We have the ability to use the rent escrow process. And we still have these chronic landlords that people are using every system that's in place, and they still can't get compliance out of the landlords. So it's not to duplicate the existing processes. It's to say, what in addition to those processes could our state agencies do to help intervene? So that's what they're tasked with doing. It's not to say how can you do what they're already doing, but what additionally could be done at a state level to support and intervene in these processes.
Let's just say we found 20 properties, I'm making this up, and, you know, 5 are in Howard and 5 are in Anne Arundel, 5 in Baltimore, 5 in Hartford. Would you anticipate the report then to the state level people here would go and talk to Hartford County, figure out all their local rules, regulations, frameworks, enforcements, limitations, and expertise, and then for those 5 properties, after fully discussing and understanding the way Hartford County currently does it, because Hartford County is the lead in this, not the state, then the state would then write a report to reflect that particular, how we would deal with 5 properties in Hartford County. Then they would go to Howard and do the same thing, intensely relying on Howard County and all that information, and then write something up and so on and so forth. Is that how you see? Because what they would write about a property has to be understood in the county in which it exists. Because what might work or what might, you know, you might want to do in Baltimore City might be impossible and not necessarily acceptable to something in Hartford County. So how would the report get written?
That's one methodology.
Okay.
But let's say they wanted to look at the courts as another methodology. Let's say they did a survey of all the rent escrow filings. And let's say what they wanted to do was set up a system where the administrative judge of the district courts could do a referral system. If they saw that there were multiple repeat filings and multiple repeat findings in rent escrow cases against the same landlord, and they wanted to set up a system where they could do a referral for that same landlord to the Office of Landlord and Tenant Affairs. And then if the report said you need to now be monitored by Office of Landlord and Tenant Affairs and have some sort of compliance period where DHCD had some sort of oversight in an intervention sort of way, maybe under the Consumer Protection Act, maybe under Office of Landlord Tenant Affairs where the tenants got additional support, maybe then they had compliance under the OAG's office. I don't know what the report will come up with, but they certainly could take a county by county approach where they looked at the county's code enforcement. I don't suspect that's what they would do. Or they could look at the state resources and all of the state players that are a part of what happens already, and they could instead do it that way. But again, it's not a complicated bill. It simply is a bill that says they would look at the existing resources and authorities, and they would come back to us with a plan. That's all.
Well, I think it is complicated, not in how it's spoken or described, but in how it would be done. And I think it doesn't have enough guidance. Now it sounds like we would bring the judicial. I don't know how you could possibly get into the judiciary and the escrow without another player, which I hadn't even thought about, but that's important, that they ought to be a full participant in the study, because I don't know how else you could accomplish some good idea. I mean, I'm not against what you just discussed as a remedy, perhaps in a particular jurisdiction, but not in all 23. Okay, so anyway, I am struggling with what I said, but I don't need to repeat myself. Thank you very much.
I appreciate it.
So there was a motion, it was seconded, we've had discussion. Let's do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
I agree with the sponsor. It seems pretty simple to me. I mean, we have a lot of substandard housing across the state. We stood up this Office of Tenant and Landlord Affairs to help address these kinds of issues. So I say yes.
Senator West.
Yes.
Senator Muse.
I agree with my cousin Sidnor, and I'm going to say, as he wanted me, yes.
Cousins.
Senator Folden.
No.
Senator James.
No, and I would just incorporate the comments from the Attorney General's office, which were multitudinous. I hope we can work it through. But for right now, those concerns, I don't think the bill has been amended in a way that addresses it. So regrettably, I'm going to have to vote no.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
Yes.
Senator Charles.
Yes.
Chairman Smith.
Yes. Was it 9? 9-2. All right, we're now going to go, two more bills. We're going to do Senate Bill 661, which is Jamie, and then we'll go back to Senator Henson.
Senate Bill 661 authorizes the district court or a circuit court during a criminal trial or hearing to receive into evidence an intercepted wire, oral, or electronic communication and evidence derived from it, regardless of whether the disclosure of the communication would violate the state's Wiretapping and Electronic Surveillance Act if specified requirements are met. Even if these requirements are satisfied, a court may not receive the communication and evidence derived from it into evidence unless the proponent gives the adverse party notice of their intention to offer the communication and evidence and provides the name and address of the party whose communication was intercepted. Notice must be given sufficiently in advance of the trial or hearing, but not later than 14 calendar days before the trial or hearing, to allow the adverse party a fair opportunity to prepare. This bill was on an earlier voting list, I believe from last week, and there is an amendment that builds on an amendment that was in the voting packet at the earlier voting session. That amendment in your voting packet today is SB 661-603-729. And if I could direct you to page 2 of the reprint, I'll just read the what the provision would read in full. Subject to paragraph 2 of this subsection, if any wire, oral, or electronic communication has been intercepted, the contents of the communication and evidence derived from the communication may be received into evidence in a criminal trial or hearing before the district court or circuit court if the court determines that, 1, in the case in which the communication is offered, the person who intercepted the communication was a victim or was in imminent danger of becoming a victim of either a crime of violence under 14101 of the criminal law article or an assault in the second degree that is a domestically related crime as defined by section 6233 of the criminal procedure article. The communication is a recording of or is part of a recording of the commission or attempted commission against the person who intercepted the communication of a crime of violence under 14101 or an assault in the second degree that is domestically related. 3, the contents of the communication and evidence derived from the communication are more probative on the point for which they are offered than any other evidence that the proponent can procure through reasonable efforts. And 4, the interest of justice will be best served by the admission into evidence of the contents of the communication and evidence derived from the communication. The notice requirement would remain in the bill. There is a provision that's added below line 13 on page 3 that would provide that this section may not be construed to abrogate or limit any rule relating to the admissibility of evidence under the Maryland rules.
Thank you, Mr. Chair. This amendment comes out of our previous discussions on this bill, and it narrows it, as counsel said, to a crime of violence or an assault that is in the second degree domestically related, which is what we were talking about, trying to ensure that if someone is being abused and they happen to record it, then that can be brought in. So I appreciate that. I do have one note, counsel, where it says assault in the second degree that is a domestically related crime. I think that should be criminal procedure article, not criminal law article. Right. Thank you. And with that, I appreciate everybody's work and would like to move the amendments.
Second, that's correct. Yes. All right. So, all right. I'd like to adopt the amendment and start on the amendments. Let me speak on that. All right. So Senator Folden was next, and then Senator Sidnor.
Thank you, Mr. Chair. So I just want to be sure I understand this correctly, because this just changed a lot since I was last a part of the discussion. So we are removing we took stalking, stalking was taken out. Did we remedy the issue that it would still be a felony if they recorded it?
It deals with the admissibility aspect of the wiretap statute still.
So they could still be convicted of a felony?
Yeah, it would still be a crime to
So
record.
I just want to be clear. So we just voted. I just want to make sure I'm clear on what we're doing here. This body, this committee just voted to allow the piercing of the veil of the two-party consent rule for non-imminent serious bodily injury and not make them a felon? Is that correct?
It's an exception, yes.
So it'd be an exception. So they're an exception for fair housing, but victims of imminent serious bodily injury or death are still potentially felons. That's what we're doing here. I just want to be clear. Because to me, this bill should have been moved first before we had any discussion about the other, because this is a far more serious issue that is prevalent across our state, and we have made an exception in this committee for fair housing people to record others, and we're not protecting victims of imminent, it's in the bill, imminent danger of becoming a victim. So, and I don't even agree with that language, because it should have been imminent danger of serious bodily injury and harm, which is, I think, what was the original language back a couple years ago, because now this has watered it down that a second-degree assault domestically related. So if I'm having an argument with my spouse and I'm like, I'm getting out of here, and she's in the front of me and I'm like, get out of the way, I'm moving. Right now, that's a second-degree assault. This is unbelievable that this committee, as brilliant of minds we have in this committee, we move an exception for something. Mr. Chairman, I'm being respectful here.
Yeah, I mean,
Why am I being interrupted?
No, just the idea, not the.
But nobody else is being interrupted. I'm simply
Because I
pointing
just don't
out
want-
the issues.
No, and I respect that. I think that's
Okay,
great.
I'm
No,
done.
keep
Thank you. No,
keep going. The brilliant minds comment was the one that.
It is brilliant minds.
Yeah.
Brilliant minds.
I agree with that.
There's
Yeah.
brilliant minds here, but we can't get past the idea that this is not okay, that we are putting things out of order. Unbelievable.
I want to thank Senator Folden, and I understand his frustration and desire to help as I do. And we heard from the state's attorneys that they would have to grant immunity if they were going to bring this in. So that was the balancing act that we made. I hear you, and I respect that, and I hope you'll still support the bill.
It appears to me that we didn't need to do that because you could have made an exception. So we sold out to move one bill without serious imminent bodily injury or death being right in front of you. We sold out a vote because someone said, oh, we're going to move 661. Okay, then I'll vote for this one. So on a bad premise, not in good faith. This language is not anywhere near where it should be. And I understand what the state's attorney's office is trying to say because they just want to get something on the books. But we took out was in imminent danger, and that's what it says now. And we took out in fear of serious imminent bodily danger, bodily injury or death. That should be the standard. If I'm afraid that I'm going to be killed or beaten to a pulp, then I should be able to defend myself and have it documented for court without being a felon. But we don't have that exception here. We don't have it, but we have it for fair housing. That is absolutely an egregious insult to every victim of domestic violence to say that we have an out-of-control fair housing market that it's so egregious, we need to put an exception in there for them to violate and pierce the two-party consent rule. But we're not going to worry so much about the victims of domestic violence, who, mind you, are beaten, hospitalized, and sometimes die. Right away, no one in the fair housing industry is being beaten or potentially going to die. Irreparable injury. But we moved that. That's a shame. We let down every victim in the state by moving it with this language. This language is not to where it should be. It's reduced down to being just something that is, oh, let's pass it. It looks great. We are forgetting about the serious imminent threats that these victims deal with when they're assaulted. We're still not carving them out to protect them from being felons. And we're saying that we're making it worse because now we're saying if the husband or the violator goes by their wife and just moves her out of the way and says, get out of the way, I'm getting out of my kitchen because we're having a big old dust up, that's a second-degree assault. And she's going to be allowed to record that as a felon at that point for admissibility. This is absolutely just poor legislative responsibility. Poor.
Thank you. First of all, I wanted to say the continuing downplaying of fair housing violations to me is offensive. There were people and have been people who have been killed attempting to move into all-white neighborhoods, people who are harassed and murdered because of fair housing issues. Has this been something that's lately happened in this state? No, it's not happening to the extent that it was happening 20, 30 years ago. But it is a serious problem when you have people who discriminate against others because of the color of their skin, because of who they may love, and and onward. So I just wanted to make certain that it was clear that I said that. Secondly, I was actually in agreement with Senator Folden. I was going to ask a similar question. However, unlike Senator Folden, I think that if the state's attorneys are going to give immunity, I think that makes sense. That that allays any concern that I would have. My whole premise behind supporting this legislation, behind supporting the Fair Housing Testing Bill, is essentially this. We've made policy decisions on things that are criminal and things that are civilly unacceptable. Now, if you don't provide an enforcement mechanism to ensure that those acts aren't happening, then you've done absolutely nothing. Thank you.
I hear what Senator Folden is saying, and to say that this does nothing for victims of domestic violence and that we are leaving them behind is a dagger to my heart. But I think this moves things forward, and I'd like to move forward. And I'd like to move forward.
Senator Folden.
I would like to make, I'm going to make an olive branch extension here to compromise to the same exception that we just gave to fair housing through an amendment. There is zero reason we should be relying on a state's attorney to decide if a victim of a domestic assault should be given immunity. We're not giving that standard to the fair housing assessors, and we should certainly not have that threshold or that responsibility of the local state's attorney to put it on victims of domestic violence. So first of all, I'd like to make an amendment that happens, and I am not okay with how this is worded now, a second degree assault without having serious imminent bodily injury or death. That language is important in the law, and it's there for an assault in the first degree for a reason. It is there for a reason. And with that, I would like those two amendments to be taken in consideration on this very, very important bill.
On discussion, Mr. Chair. First, it is incredibly offensive to have these two very important subject matters pitted against each other, and to have them discussed in that way as though one is more or less important than the other. I think this is why we have a single subject matter rule and why we consider each of the bills and all of the legislation as one and not consider them as gladiator style, where you take two bills and you pit them against the other. Because I think we are bound to offend when we do that, because they all stand on their own merits. When we look at this bill and we look at the intimacy of communication, when you are dealing with people who are communicating in a situation where there's domestic violence, I think that you want to be able to preserve a certain amount of intimate communication. You could have husband and wife where their communication is privileged. You could have intimate partners where the level of communication that they have is just different. If we are comparing the communication that happens in the context of fair housing and comparing the level of evidence that you would have to meet your evidentiary burden and the tools that you might have at your disposal, it is just different. That communication that you have in a fair housing context, that recording may be the only thing that you have to prove your standard of proof. Whereas when we're talking about crimes of violence, you may unfortunately have documented injuries. You may unfortunately have property damage. You may unfortunately have a record of abuse. You may unfortunately have a number of other elements that prove proof the elements of the crime that is the cause of action. So to take the two things and to put them together and to debate the two bills as if they must have exact parity is the exact reason that we don't do that, because the facts of them are different. The standard of proof is different. The evidence that you would have in those two cases would be very, very different when you are looking at what is required for one and what is required for the other. And you are shaking your head, Senator, but it is very, very different when you are talking about how do you build a case to, I'm an attorney, I practice law every day. And if I'm putting together a case for a fair housing discrimination, the sort of evidence that I need to meet my burden of proof when I'm talking about someone's intent and their discriminatory conduct, that's very, very different than if I'm talking about injuries to someone, how I go about proving that. So to say that if we have a standard for one, it must be the standard for all, it's a reason we don't do that. And that's because different subjects, different standards. So to say that if we support one and we don't support the other in the same way, that we have neglected our duties to victims in one context is offensive, and it is wrong. And it is the reason that we don't do that, because that does not make sense. So, Mr. Chairman, I think that this committee put a great deal of work into trying to figure out how we protect the privacy and intimacy of communications that can be different when you are in a domestic context, to make sure that when those lines are crossed and we have to protect people who are harmed, that there are ways that those communications can be entered into evidence, but that you still have some measure of privacy in an intimate communication as well. And I think that's what you saw adopted in the language of the bill and the amendments as well. Thank you.
So I'm not trying to make a monumental case out of this, and in my opinion, this is exactly the single subject matter. It's two-party consent. That's what this is about. That's why they can be compared, because we haven't pierced the veil of two-party consent in this state in this manner. However, the burden of proof for a criminal case is the same. Proof beyond a reasonable doubt. So I appreciate your words. We are seeing this from different optics and different lenses, and I appreciate the dialogue. But this is the issue, is the two-party consent. That is the single subject matter at hand here. So I made a motion. I thought there was a second. I thought there was a second to my motion.
I'll second it.
I just wanted to chime in on this conversation. The two-party consent rule is so problematic. The law is just riddled with exceptions to it, and each exception is different. So I think it's fair to talk about each exception in isolation and not to try to compare the exceptions as if they're two different apples, because frequently the exceptions are different from each other. So I think under the circumstances, because there's so many exceptions, we need to discuss each one independently. That said, I'm worried about, in this particular case, how this is going to come up. And Senator Hinson talked about how she's a practicing lawyer. So I think you're going to get a battered spouse who consults with an attorney and says, what can I do? And the attorney, in his or her discharge of their attorney-client function, will say, well, one possibility is for you to tape what goes on the next time. Have it recorded in your apartment or in your house, so when your spouse physically abuses you, it's caught on camera. They said that could be used, based on this exception, if we pass this, in court against your husband. On the other hand, the attorney would have to advise his client, if you do that, you are subjecting yourself to potential criminal liability as a felon for having violated the two-party consent rule. And it will all depend on whether the attorney, the state's attorney in the case who's assigned to your case, is going to give you immunity, or is going to prosecute you. Now, if I'm a battered spouse, I don't want to hear that kind of advice. The spouse is going to say, well, what's the attorney going to do? And the state's attorney is going to, excuse me, and the lawyer is going to say, I have no idea what the state's attorney is going to do. I know what I would do if I were the state's attorney, but I may not, the state's attorney who's assigned to your case may do something totally different. So I feel that if we are going to pass this as an exception in terms of allowing evidence into court, it only would make sense to make the person who is capturing this information exempt from the two-party exempt law, two-party consent law, so that that party would not feel personally endangered if the party attempts to capture this information, which would be cognizable in a court proceeding. That's my feeling, which is why I'm willing to second Senator Holden's proposed amendment.
Okay, so what you said, I mean, absent the destination you arrived at, what you said is absolutely true, right? I mean, so we'll talk about that. Senator Folden's amendment has two parts of an amendment. We're going to reduce those amendments to writing for the committee to consider, but at the moment, I'm going to hold the bill for now. We've still got plenty of time. We'll do further discussion, and we'll entertain those amendments in writing so that everyone can see. But I think a lot of valid points have been brought up, and this engenders a little bit further discussion. So I'm going to hold the bill, and we'll reduce those amendments to writing, and we'll have further discussion before we come out and vote tomorrow. All right, Senate Bill 626.
Senate Bill 626 repeals the requirement that a licensed healthcare practitioner determine that an individual's sex designation should be changed for the purposes of issuing a new birth certificate. Instead, the individual must make a written request under penalty of perjury to the Department of Health for a new birth certificate with a sex designation that differs from their original birth certificate. When issuing a new birth certificate, the Secretary of Health must allow an individual to designate the sex of the individual as female, male, or unspecified or another. If an individual indicates unspecified or another, the Secretary must ensure that the new birth certificate displays an X in the location that indicates the individual's sex. And furthermore, the bill alters provisions regarding a new birth certificate issued due to a name change of a listed parent on the birth certificate.
So how does this equate to real ID? Yeah. I know that I had to go get a copy of my birth certificate because it wasn't the official transcript when I was born, and had to go get that because I needed the official to go to the MVA so I could be real ID compliant in the federal. So my question is, how does an X on a birth certificate reflect real ID, it may not?
Senator Love can answer that, but also there's federal legislation pending.
Well, a bill that the chair and I had years ago allowed for that on your driver's license, and that does comply with real ID because that came up in that debate.
Okay.
Senator Fuller.
Thank you. So how does this work as far as, I mean, isn't a birth certificate considered a historical document?
Yeah, I mean, current law does allow you to receive a new birth certificate, which would be as official as the original. I mean, there are obviously
Yeah, I mean, but
procedures
it's
which
the
are being
same
adjusted
one.
here.
It's a copy of the same one
Well,
as
in
a
this,
new birth certificate.
yeah, I mean, in this case, some information would be changed. You could,
So
change the sex or-
currently under law, what can you get as an adult with a new birth certificate, mind you, a record of birth, thereby a historical document? What can you change on that now as an adult?
So you currently can change the sex designation, however, it requires a licensed healthcare practitioner to determine that you've undergone appropriate treatment for that. And the
Treatment
bill,
meaning transition?
Yeah, so the phrase in the current statute is that the individual's sex designation should be changed because the individual has undergone treatment appropriate for the purpose of sex transition or has been diagnosed with an intersex condition. That's the language that's being repealed,
It's been diagnosed with a what?
an intersex condition.
So that language is being repealed
Correct.
because that indicates that they may have, I don't even know how to word it. So we're now, so it doesn't require them to actually have the transition.
So the language is,
We would base this on feelings again.
well, has made a written request under penalty of perjury
They
for a
don't have to
new,
have transition.
a new certificate of birth with a sex designation that differs from the sex designated on the original birth certificate.
The answer is no.
No,
So
I-
we're repealing language that at least allowed a mental health or provider doc say that this person identifies this way. But at the end of the day, they can still be a male for all intents and purposes by birth and choose to change their birth certificate, which would not be consistent with their actual anatomical things to
Yeah.
right?
I mean, the only thing that I'll say is the bill does add, the phrase under penalty of perjury, but it does not specify what exact, it's just that the request, it's made a written request under penalty of perjury for a new certificate of birth with a sex designation that differs from the sex designated on the original certificate of birth. So that's now the requirement.
We can make this a crime now if they go, is what I'm hearing, if they go and change it contrary to what they are anatomically, that if they actually go and do that, then someone could go and charge them with perjury for changing an official government document and history of a recorded birth. So let me ask you, who does that charging? Can there be groups that go around and just kind of check these out and be like, you know what? I'm going to go through all the certificate of vital records and see who has changed their birth or their sex at birth and what they are today. And I'm going to ask them to be charged. Are we going to leave that up to the state's attorney's office too?
I mean, possible. I think the other question is what exactly about the request has to be made under penalty of perjury?
Well, what is the criteria?
Nothing.
It's not clear to me exactly what is under penalty of perjury.
So as written now, can someone go in who is anatomically, for all intents and purposes, a man, go in and change their living record of birth, a historical document, to say that they are a female because based on how they feel?
Any reason, no reason.
Or, yeah, no reason at all, really, just because they want to change it. Does that then I mean, there's just so many things beyond this. I mean, that would open up like MBE type opportunities. You could defraud the government then. I just, so there's nothing in the bill that says what that penalty would be other than the penalty of perjury, and that,
Even though information is being affirmed. Yeah, but what are you affirming?
Thank you, Mr. Chair. A couple of things. To say, based on how you feel, I find incredibly offensive to trans people, number one. Number two, this actually has more application beyond trans people. And it's not, number three, this is no longer a historical document. Birth certificates are being required more and more and more, and especially under the federal SAVE Act, you're going to need to bring that in. And let's think about a married woman who decides to change her name. And she goes in to register her kid at school. Her driver's license isn't going to match her birth certificate. Under the new SAVE Act, her passport isn't going to match her birth certificate. So she's not going to be able to register to vote. So this has much broader, no, that is, yes, it is.
Not true, Mr. Chair.
Sorry, go ahead.
Can I?
Conflate
Hold on,
national
let's,
issues into a
All
bill
right,
that
let's-
actually we should be listening to her.
All right, yes.
But not inflate national issues.
Senator, may I finish?
Senator McKay is going to be next, but Senator Love has the floor.
Thank you. If you would like me to finish my sentence on that, she could go through a huge number of hoops to get that voting. But this is going to make it a lot cleaner. And so I've now lost my train of thought. So this bill is a lot broader than just trans. And even if it were for just trans folks, we should respect who they are and let them have the identity and the documents. We've already said that you can change your driver's license. That is the law in our state. We should allow them to have the birth certificate documents that they need. And the last point I wanted to put in here is the only reason this bill is cross-assigned or jointly assigned is for the last page on transportation. This has been thoroughly vetted by the Finance Committee, where the majority of this bill falls. So we're only here because of the last page, 12305, line 9. So I would ask us to focus on what our role is here and pass this bill. Thank you.
How can putting an X on your birth certificate have vast more than somebody who is not, would like to have their sex changed on the, from going M to F? How does that have more broadening for everything, including married women who are then going to go for their voting? How? I mean, that was your statement. How is that, Senator? I mean, it's more than just trans people. How?
It's your name. It's your name on your birth certificate.
No, it's not your name on your birth certificate. It's not your name. It's the section called gender. You're putting an X there. It's not your name.
In looking at this bill, I'm reflecting on some sort of a documentary or something that I remember watching some years ago that was, I think, about how babies being born had multiple genitalia, or it was difficult to determine their genitalia and whether it was an enlarged clitoris or a small penis, since I think those were the words that we were kind of trying to figure out. And doctors made that choice. So doctors were playing God in determining whether this baby, this newborn baby, was a male or a female. about any other information, and then you had children growing up who never felt right in that particular gender that was assigned to them by the God doctor. So when I look at this legislation, I mean, I know we've talked about transgendered people, but I think this is, I mean, to me, this is kind of some of the population that you may be capturing with this. So I just felt a need to say that.
So I'm curious to know what the numbers are, because I'm pretty sure it's in the very, 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 very minority, small fraction of a percent of the incidents that the senator is talking about of doctors making the decision, I guess, based off of what the parents' recommendation would be. So it's not the doctor doing that, it would be the parents giving that direction. My follow-up question is to council, is nowhere in here that I'm seeing, does it say that they have to be an adult to make this decision? Did I miss something?
Yeah, so I believe if they are, so if they are a minor, then it has to be the individual's parent, guardian, or legal representative.
So this is, I mean, we've just had quite a controversial federal couple years on children having transition surgeries, and now they're suing their doctors who encourage certain things and winning. So here again, depending on the parent now, not based on the facts of what is in front of them, we are going to allow the altering of an actual recorded historic document. Unlike a driver's license, which is a permit issued by the state, this is a record of birth. Those are two different things entirely. So I've got to, I mean, is there a large movement that I'm unaware of to go back and record these? Because I'm shocked that this is where we're going to look to move to allow someone, not based on the premise of fact, because to the senator's comment, where she made the comment about that it was an insult, I guess, based on that I said how they feel, but the reality is it's a basis of fact, is what is present, what they are at that time. So they would be committing perjury. So we're creating an opportunity for one specific block on a historical document, which is done at birth, and accurate, whether you agree with how it was assigned on certain very small, minuscule cases, that we're going to allow them, children and or adults, to go back and change an historic document that's not consistent with how they are anatomically.
All right, Senator Folden, thank you for that. We're going to hold this bill, and we will revisit this dialogue at a later moment. All right, we're now going to move on to Senate Bill, Shamar, are you ready to go? Senate Bill 937.
Senate Bill 937 generally establishes certain restrictions on a landlord's use of a prospective tenant's criminal history records, in addition to other prohibitions. Among other provisions, the bill also, 1, reduces from 7 to 3 years the applicable period of criminal history included in a reusable tenant screening report, and 2, mandates the data, collection, and annual publication of related complaint information by the Office of the Attorney General. Violation of the bill is an unfair, abusive, or deceptive trade practice under the Maryland Consumer Protection Act, generally subject to the MCPA's enforcement and civil penalty provisions. A violator is subject to a maximum fine of $1,000 for each violation.
All right, there's a motion for favorable. It's been seconded. We've got, no, there's no amendment. Senator Fulton.
Man. So, correct me if I'm wrong, Shamari. So we're looking to move legislation.
Hold on, speak. There are amendments, so.
Yeah, also, I think we did.
Oh, I'm asking.
That's what I.
Do we?
Which I thought.
Can we go?
We didn't have anything wrong. Oh, no. Wrong.
All right, Senator Fulton, no amendments.
No amendments, okay. So, holding the bill? Okay.
While we're sussing that out, we're going to go to Senate Bill 290. Yeah, 290. 290.
That's the reparations.
Stinky bill.
Go ahead, Sandy. Thank you. Senate Bill 290 increases from $1,000 to $5,000 the maximum civil and criminal fines and penalties Baltimore City may impose for a violation of any ordinance, rule, or regulation established by the city as specified. There is a delegation letter and proposed amendment in your voting packet. The proposed amendment would strike the provision of the bill relating to maximum fines or penalties in dollar amounts. Instead, as amended, the city charter would provide in part that the city may provide civil and criminal fines and penalties for the violation of any ordinance, rule, or regulation established by the city under or in the execution of any power granted by this Article 2, provided that no imprisonment shall be for longer than a period of 12 months. So that strikes the cap on fines and monetary penalties.
Then I'll ask her then. So with that change, it seems that is there an allowance for a fine or a penalty other than being imprisoned?
Thank you for the question, Senator. So the intent of the amendment, which was proposed by the delegation members, was that the General Assembly would no longer impose a cap and that the City Council by ordinance would be responsible for making alterations to fines and penalties for city violations.
So there's something else in addition to this?
That is the bill as amended. It would just remove that the General Assembly is imposing a maximum amount. So the city would then be responsible for imposing whatever amount of penalties, and that would have to pass by ordinance of the City Council.
So I'm just curious, why would the language not say, provided that no fine or penalty as established by Baltimore City, or something that says that there's something outside of being imprisoned. That's what I'm trying to understand. If we're only referencing imprisonment, then why would one think that there could be a fine or a penalty rather than just imprisonment? That's what I'm trying to understand.
So, Senator, if you go to the reprint of the amendment, that's Article 2, Section 48, begins at line 23 on page 1 of the reprint. So this is addressing that the mayor and city council have full power and authority to exercise, these following powers, and they can provide civil and criminal fines and penalties. So their authority to develop fines and penalties is there. What the amendment is doing is uncapping the maximum fine that they could impose. The imprisonment would still be capped at 12 months, but as far as fines, it would be unlimited.
Did the delegation letter support the initial bill or the amendment?
The bill as amended.
Well, we can let's adopt the amendment. Is that okay? All right, now the bill is before you as amended. Discussion. We're on 290. A motion for a favorable?
With amendment.
With the amendment. Is everyone, okay, it's in second. Is everyone okay being recorded in the affirmative? All right, Senate Bill 290 as amended passes unanimously. Thanks.
Yes, the House version should be crossing over. Yep. Okay, sure.
All right, Senate Bill 822.
Senate Bill 822 establishes that the Parole Commission does not have the authority to permanently deny parole, and that an incarcerated individual is entitled to a subsequent parole hearing at specified intervals based on the length of their sentence after denial of parole. In addition, the bill establishes requirements for hearing and recordings of hearings. It alters the information that the commission must consider when determining whether an incarcerated individual is suitable for parole. It alters the information that the commission must provide to an incarcerated individual before a parole hearing. It requires that each commissioner's reasoning and the justification for their vote to approve or deny parole be made available to the public. It decreases from 21 to 14 days the period of time after a hearing within which the hearing examiner must give a written report of their findings and recommendations to approve or deny parole to the commission. And it requires prompt written notice of the Parole Commission's final decision, and it expands the information that's included in the commission's annual report to the governor. There is an amendment in your packet. It's number 873-525/1. The amendment does several things. First, it further expands the Parole Commission's annual report. It requires specified notice and information to be provided to the incarcerated individual's representative, in addition to the incarcerated individual themselves. It specifies the certain specific information that must be made available to the incarcerated individual. It expands from 5 to 30 days the time for either the incarcerated individual or the Commissioner of Correction to appeal the decision of the Parole Commission. And finally, it prohibits a county from being a party to an administrative proceeding under the Walter Lomax Act, which is the provision of law that allows a wrongfully convicted and incarcerated individual to seek compensation from the state. On that point, so the counties were made partially responsible for those payouts to wrongfully convicted individuals, so they have been intervening in these administrative proceedings and making arguments against awarding, awards to exonerees. So what the amendment would do is basically say a county may not be a party to one of those proceedings, so they would not be able to intervene anymore.
They've been denying payments in these administrative proceedings, and they've been denying payments.
Because the counties are now partially responsible for the payouts, so they've been arguing they have standing to intervene and make arguments against.
All right, just adopt the amendment, and then have the discussion on the amended bill. Is everyone okay? Just, now the bill's before you as amended. Just for the record, though, that also means that the counties aren't, the burden is not going to be shifted or to or away from the county. The state will still, yeah. As they are now, the assignment of liability or the payouts are not going to, that's not going to change. It's not going to shift anything more or less to any other party that is already responsible right now. Senator Fulton.
Thank you, Mr. Chair. Did any, I'm going to apologize, but Josh, did any of the amendments that you just discussed take into consideration the Maryland Crime Victims Resource Center, their concerns?
I don't recall whether it was in the bill as drafted or an amendment, but
Says it's like the intrusive administrative requirements upon the operation of the Maryland Parole Commission that have not been shown to be warranted.
Have that shown?
It says that proposes many intrusive administrative requirements upon the operation of the Maryland Parole Commission that have not been shown to be warranted. It will strip the commissioners of the power to establish justifiable calendar, when the next hearing parole cases, which they're familiar with.
The amendments, so I think the bill addresses that, but the amendments deal strictly with the Lomax issue and the payments and the counties.
Say that again.
The amendments do not address any of that. I think the bill does, but we can talk about that on the merits. But the amendments that are just offered and adopted only deal with the manner in which the Walter Lomax payments for wrongfully incarcerated individuals.
So that's the amendment. Okay, so but the bill itself doesn't address, or so no amendment added today addresses the concerns of re-traumatizing crime victims by automatically scheduling parole hearings at times when there is no reasonable chance of parole. And that violates the crime victim's right to be treated with the sensitivity and respect guaranteed by Article 47A of the Maryland Declaration of Rights.
No, the bill provides for obviously the submission and participation in the process with the victims or their families, and
But does
also
it speed up?
a mandatory evaluation, a mandatory consideration of prior victim impact statement has to be part of it. The piece that's, which is something that we came up during the hearing, is that if you have a schedule that's regular, then you're going to get notifications. The victim's family is going to get a notification. And on one side, at least the family has an understanding of when those notifications are going to come and can kind of prepare mentally for that. On the other side, they're going to get that notification on a schedule on a regular basis. And so that's what, we tried to kind of balance that.
And that's until, so those are sent out to the victims' families or victim, and until this person would be paroled. So they're going to be constantly giving a reminder of how the state continues to move towards releasing early release of, this is another bill that is going to, once again, and I had in my notes that I was originally supporting this. So this is another pro or movement to guaranteeing earlier and more frequent hearings other than what would be otherwise currently required.
Yeah, I mean, the
Is that
evaluation
correct?
process is still going to be the same. So someone, I mean, look,
The what process? I'm sorry.
the
Evaluation.
Yeah, yeah. So, yeah, I mean, it's going to set up a regular schedule, but it's not going to change the manner in which those individuals are evaluated. But it will give an incarcerated individual a clearer understanding of where they fell short, what benchmarks they can hit, if that's a viable option. So it will give that individual the ability to.
And what was the other part about some monetary, the amendment?
Oh, that's about wrongful incarceration or something.
That's wrongful incarceration, is that?
That's an amendment that's being added on for the Walter Lomax Act that we passed that was wrong. Those are folks that are wrongfully convicted, incarcerated. There's the payouts that the state pays out.
But that's
part of that bill kind of bifurcated the payments. One part would come from the state, part would come from the county in which the wrongful conviction happened. And what's happening right now is that the counties are intervening through an administrative process and slowing up the process so that the payments are not getting processed. And so this
All right.
bill, the amendment seeks to fix that problem.
But that seems like a different hearing than what this bill is. This bill is about the frequency and notification of hearings for incarcerated individuals. The amendment deals with some type of civil recourse for another bill that was passed because the counties are intervening. That's how, I'm just curious how that's.
It's a problem we've identified and we need to.
But how is that not a
vehicle.
separate bill, Mr. Chair? I mean,
No,
that's,
I understand that.
this is, if we're talking about this, the single party or single.
subject.
Single subject, how is that?
It's a
Those are two
problem.
separate things.
It's a problem we've identified. It's something that we'd like to remedy with urgency, and so we've tacked it onto a vehicle that we found that does not violate the single subject because of the underlying.
Do we
subject
have
matter.
do we have a AG's letter that says that it's not violating the single subject matter?
I don't, but I'm happy to get that with you.
Yeah, I'd love to see that because it seems like while it's dealing with inmates, that's about the only commonality. One's saying that they're wrongfully incarcerated, the other ones are justifiably incarcerated. We're just trying to move them out sooner and re-victimize and re-traumatize the victims. Thank you.
The amendment has been adopted. There's been a motion for a favorable. I'm
opposed to the amendment.
Okay, the amendment, just for the record, we'll make sure Sandy has you down on the amendment. On the amendment. No, I hear you. All right. Now the bill is before you as amended. There's a motion for a favorable. We're going to do a roll call.
Vice Chair Walstrecker?
Yes.
Senator Sidnor?
Yes.
Senator West?
Pass for the moment.
Senator Muse?
Yes.
Senator Folden?
No.
Senator James?
Yes.
Senator Hinson?
Yes.
Senator Love?
Yes.
Senator McKay?
Nay.
Senator Charles?
Yes.
And Chair Smith?
Yes.
It didn't matter.
No.
All right, bill passes 8-3 as amended. All right, so Senator James, and then
If somebody's in prison and they kill another inmate, and the commission wants to say they're permanently denied parole for that reason, does that, who decides that? And all I want to know is that we don't take away, sorry about this, don't, you know, it could be that you have to go to court, so I'm not sure about that, whether you go to court for that and go to a murder trial for that. Or let's say you don't murder somebody, just really injure them badly. You know, so the bill says they've lost the authority to permanently deny parole. Does anybody have the authority to permanently deny parole depending on the conduct of the incarcerated individual? How do we hold people accountable in prison?
So, I mean,
for stuff like that?
first of all, I mean, if you commit another crime while incarcerated, that is something you can be prosecuted for. But on the point about permanent denial, we got kind of conflicting information. The commission themselves, their position is they do not do that, although there was some testimony that indicated that it happens. So it's a little bit unclear. Yeah, that's essentially, I think the testimony was sometimes they just will not give it, and that was equated with a permanent denial, but the official position is the parole commission does not do that.
Stop whatever they're talking about is not the language here, but I'm not going to correct the bill. But just so I can understand, if you do something really egregious in prison, and everybody sort of agrees, we used to say, you know, you're not getting out for that. Who makes that decision now, now that we passed the bill? How do we, who is it the parole commission still, they wouldn't permanently deny it like forthrightly, but they would just continuously refer back to this very egregious thing you did and deny your parole, right?
Right,
I just want to make sure we haven't
yeah.
lost some abilities to keep very bad behavior accountable. Am I right?
And under current law, there is no kind of required schedule for hearings, so it could just be done in a way that they simply don't grant a new hearing to somebody
So
in the
if you
first
have
place.
particularly egregious behavior, even under this bill now, that too could be, you could just not be granting people hearings for parole because of egregious behavior.
No, I mean, so unless they received a sentence of life without the possibility of parole, you would still, so if they received, so the schedule in the
I'm asking
bill.
after we voted, Mr.
no,
Chairman.
we actually do have to get to the floor. It's 4:30.
Oh, I'm sorry.
No, so let's take this offline and get more
Yep,
education.
that's fine. Thank
right,
you.
next.
Apologies.
Thank you.
I